Hello everyone, this is Attorney Felix Hagenimana. I debated for several days whether I should make this video. My first instinct was to remain silent and allow the legal process to take its course. As an attorney, I believe disputes should be ultimately resolved in the courtroom, not in the media. But over the past several days, I have received phone calls, text messages, and messages on social media from people who have known me over the years, asking me one simple question: what happened? Many of you have trusted me with your immigration cases. Many of you referred your family members and friends to my office. Many of you have prayed for me and reached out simply to ask whether everything you have been reading is true. I felt that I owed you an explanation. First, I want to acknowledge that disciplinary proceedings against me are currently pending. I respect that process, and I intend to fully cooperate and respond to every allegation through the appropriate legal channels. At the same time, I also believe it is important that the people who know me hear directly from me, because some of the public reporting contains factual inaccuracies and omits important context that I believe is essential to understanding what actually happened. Since becoming an attorney in 2018, I have dedicated my career almost exclusively to representing people facing deportation. These are some of the most vulnerable people in our legal system. They are mothers and fathers, children, people fleeing torture, violence, and war. Representing them has never simply been a profession for me. It has been my calling. During the first 7 years of my practice, I did not receive a single professional grievance. That does not mean I'm perfect. Like every attorney, I have made mistakes. Whenever a client has expressed dissatisfaction with my representation, I have taken those concerns seriously and have always tried to learn from them. But I also believe there is an important difference between allegations and established facts. Some of the public reporting has presented allegations as though they were established truths. I would like to explain why I believe that important parts of the story are incomplete. One report stated that a former client's case was reopened because of an ineffective assistance of counsel claim against me. That is not my understanding of what the Board of Immigration Appeals ultimately decided in that case. Immediately after the immigration judge entered a removal order, I filed a motion to reopen the case and resend that removal order identifying legal defects in the proceedings. Another attorney later pursued ineffective assistance of counsel claim before the immigration court, and the court rejected this. When the case reached the Board of Immigration Appeals, the board did not reopen that case on the basis of ineffective assistance of counsel. Instead, it concluded that the client's pleadings had never been taken and that removability had not been established, a theory that was the basis of my motion to reopen that case. Before these proceedings against me started, the client in question had already asked bar counsel to withdraw his complaint, which he had previously lodged against me. Another report stated that one of my former clients was deported back to his home country because of my representation. That is also inconsistent with my understanding of the record in the case in question. The immigration judge never reached the merits of that client's asylum claim. Instead, the U.S. government presented evidence that another country to which that client had never been had agreed to accept him, and the immigration judge concluded that she lacked jurisdiction to consider the asylum application under those circumstances. To my knowledge, that client was not removed to his country of nationality, as has been publicly reported. Another impression created by the reporting is that many of my clients have been deported because of my representation. That is simply not consistent with my experience. During the 8 years that I have practiced immigration law, I'm aware of only one client whose removal ultimately occurred following my representation. In that case, the immigration judge explicitly found the client's testimony to be credible, but concluded that even accepting every fact as true, the law did not provide him protection. I appealed that decision to the Board of Immigration Appeals and continued representing him without charging additional legal fees because I believed he deserved every opportunity available under the law. Unfortunately, the board affirmed the legal ruling. I also believe it is important to provide some objective context about my practice. One of the impressions left by recent reporting is that my practice routinely failed asylum seekers, or that my caseload was made competent representation impossible. I don't believe the objective data supports that conclusion. I reviewed every completed merits hearing handled by my firm during 2025, a year that has been very difficult for asylum seekers. Our firm obtained successful outcomes in 14 of 20 completed merits cases before immigration courts. That represents an overall success rate of 70%. Broken down by court, our success rate was 63.6% in the Chelmsford Immigration Court and 77.8% in the Boston Immigration Court. For comparison, publicly available track immigration data reports that represented asylum applicants achieved success rates of approximately 39.2% in Chelmsford and 51% in Boston during the same period. I do not share those numbers because I believe statistics answer every criticism. They do not. Nor do they mean that every decision I made was correct. I share them because they provide objective context that has been missing from much of the public discussion. These results are difficult to reconcile with the public impression that my practice was one of systemic incompetence or that I routinely failed people who trusted me. I also want to clarify one more point. Some reports state that I was counsel of record in approximately 1,500 immigration cases. While that number may accurately reflect immigration court case numbers, it does not mean I had 1,500 separate or unrelated legal matters. In immigration court, every member of a family has a separate A number and a separate court case. If a family of 7 seeks asylum together, that creates 7 separate court cases and 7 separate notices of appearance, even though it is one family pursuing one underlying asylum claim. Without that context, readers could understandably conclude that I maintained 1,500 unrelated legal matters, which is simply not how immigration proceedings are structured. To my clients, I know many of you are frightened. Some of you are wondering what will happen to your cases. Some of you trust me with the most painful and personal stories of your lives. Nothing has been more painful for me than knowing that these proceedings have created uncertainty for you. Representing you has been the greatest privilege of my professional career. I sincerely regret the disruption this situation has caused and hope each of you receives the legal assistance you need while these matters are resolved, and that I will be back soon rather than later. Finally, I want to thank everyone who has reached out with prayers, encouragement, and support. Your kindness has carried me through one of the most difficult moments of my life. I'm not asking anyone to simply accept my version of events. I'm asking only that people keep an open mind. The allegations that have been reported are serious. They deserve serious and careful examination. So do court decisions. So do motions that were filed. So do statistics. And so do the complete records that tell the rest of the story. I remain confident that when all the evidence is considered, not just the initial allegations, a fuller and more accurate picture will emerge. Thank you for taking the time to listen. May God bless you, and may God continue to bless the clients and families whom I've had the privilege of serving. Thank you.